5, 4, 3, 2, 1. The 5th District Court of Appeals in Dallas, Texas is now in session. Justice Evans presiding.
All right. Thank you all for being present for our oral argument. We're hearing our cause number 05-16-744, civil case. It's Horton versus Stovall. I guess it's Hames, Horton versus Stovall. And we welcome you to the 5th Court of Appeals, although it's virtual. So let's cover a couple ground rules. Let's cover the unusual stuff first. First of all, if anybody has a technical problem, like if one of us justices just disappears or one of you two disappears, nobody panic. We will stop. We're going to ask Lisa, who's listening into us. Her camera is focused on the clock, which you see. We will ask Lisa to stop the timer as best she can immediately. We'll wait for whoever we lost to rejoin the Zoom conference, and then we will pick it up. We'll probably give whichever of you advocates is talking a few seconds to remind us of where you were. We, of course, will, if we lose one of you advocates, we, of course, will not talk about the case while you are gone, while whoever is missing is taking time to rejoin us. So nobody panic, just rejoin us. Secondly, we are going to ask, we have learned in doing these that it's best if everybody mute if you're not the speaker. So we're going to ask you lawyers if you will switch back and forth when you quote unquote come to the podium. The one who is going to talk, like Mr. Thomas, you are on live because you're going to talk first. Mr. Clark and Mr. Thomas, just switch, you're muting so that Mr. Clark, you're live, Mr. Thomas, you're muted. Many people, if there's anybody watching this on the live stream video, they may not realize that there are no objections in an appellate argument, so that our appellate advocates have no need to have their microphones on. So that's what we're doing there. Now, to the usual things, the timer, it shows there 20 minutes. Each of you gets 20 minutes. Appellant and Appellee each get a full 20 minutes on your opening arguments. It will turn orange or yellow. It appears yellow on the camera. In real life, I think it's actually more orange. At 3 minutes, so 3 minutes, you're piloting your big Boeing 737. At 3 minutes, start getting that glide path to land it on the tarmac. When it goes red, if you are not in a question and answer dialogue with a justice, you need to just say your last sentence, therefore we ask to reverse, therefore we ask to affirm, and stop. Appellant, you get an additional 5 minutes on rebuttal in addition to your 20, and the yellow or orange light 1 minute, and then the red light at the conclusion of your argument. Let me ask my colleagues, have I missed anything that I need to advise everybody about our oral argument in this process on Zoom? Okay. And counsel, we wish you and your families are all well in these unusual times, and we hope nobody in your families or your clients are ill or anything. We are ready to hear your oral arguments. We have read the briefs. We have thought about this. We've dialogued a little. We have not decided anything. We don't make our decisions. We don't conference until after we hear from both of you. And then we will, on our own Zoom, we will terminate this Zoom and go into conference. So I always encourage counsel, kind of consider this as though this is your chance to sit down with us, as though you're at the conference room table with us, and tell us why you think we should do what you're asking us to do. That's really important to us. And if we have questions, we will try to be polite. We will try to not interrupt, but we really are asking questions that will help us if you think about what you're asking and just answer, try to answer as directly as you can what we're asking. That really does help us. So with that, Mr. Thomas, ready to go?
Yes, I am, sir.
All right, sir, please go ahead and proceed.
Thank you. Thank you for having us by Zoom. My name is Bruce Thomas. I am here for the appellant, who is now known as Lisa Horton, and she was the defendant and counter plaintiff below. You could describe this case that's gone through a lot of twists and turns by now. You describe it in a lot of ways. It started out as primarily a business case and a tort case. It has now mutated into what is more of a personal case and a contract case. But at no time was it properly described as a summary judgment case, because there are a myriad of fact issues on all the claims, and each of the three summary judgments that were entered here. You can appreciate the trial court wanting to bring this case to a conclusion, but the way it should have been brought to a conclusion was putting the parties to trial, not through a series of partial summary judgments and abatement orders, because fact issues predominate. Now, let me turn to the first summary judgment motion, first motion for partial summary judgment, which was Stovall's motion for partial summary judgment on breach of contract for Horton's alleged breach of the settlement agreement. And despite the complexity of the record, this is an issue from which all other problems in the judgment from our perspective stem, and it can be readily resolved by first principles of summary judgment practice. That is, you have to have evidence, and conclusive evidence at that, to support your claim, and the trial court cannot award a summary judgment on grounds that are not supported by the motion. And that's what happened here. There's no evidence to support a $250,000 judgment for breach of contract on Stovall's first motion for summary judgment. Yet we have a $250,000, $245,000 plus interest and attorney fee judgment out there that's not supported by any damages evidence. She didn't even ask for a judgment on damages in her summary judgment motion. So of course, it's not surprising that there's not any evidence to support a damages judgment. So either way you look at it, whether the district court ordered that wasn't requested, or there's no evidence to support the judgment, it is error to have rendered the summary judgment for Stovall on her newly pleaded claim for breach of the settlement agreement after she revised her theory of the case. Now, the Appellee's response to this, as I understand it, is, well, things changed since filing the suit. She had sold the centenary property and liquidated property and placed the assets in the registry of the court. And that, so $245,000 was the number that she needed in order to go along with her requested interlocutory relief to get the proceeds out of the registry of the court. But that just isn't contract damages. All she did was liquidate the asset. She did not prove that the value was in any way altered as a result of any alleged breach of the settlement agreement. Whether there is an interlocutory distribution of proceeds and who they go to are completely distinct issues from whether there was any breach that caused damages to Horton, to Stovall by Horton. You get a damages judgment, of course, and summary judgment on what you conclusively proved, not on what you may or may not need for other reasons. The damages theory that Stovall has attempted to make out on appeal is no different than had she asserted prior to selling the property, she asserted that her damages were the entire value of her house. That just doesn't make any sense. The value of the house doesn't represent any loss that resulted from any alleged breach of contract. Well, Ms. Stovall never proved that she was damaged a penny as a result of any breach of the settlement agreement. She did make noise that the house sold for less as a result of clout on title, but she never proved that. She never associated that with any damages evidence and never pursued that with any figures in her summary judgment motion. because Stovall never established that she was entitled to any award for breach of contract because she failed to offer any evidence of damages. In this case, the summary judgment burden on this traditional motion never shifted to Horton to produce any evidence. So whether Horton's evidence was deficient or not ultimately does not matter because Stovall did not meet her burden. Nonetheless, Horton did raise fact issues in her summary judgment evidence. And essentially those are who breached first, whether the breach is material, and what exactly were the breaches. Horton alleged 4 breaches by Stovall and failing to return Horton's personal property, not refunding deposits of Horton's paychecks, not providing title to Horton's car, and not making a $25,000 cash payment to Banco Popular for the Spain property.
Let me jump.
Sir.
Okay. The Stovall side has, as a backup argument, has argued benefits estoppel. But your side, Haynes Horton, is not denying that there was a contract. You're arguing that Stovall breached it first, right?
Well, we're doing both. The first part, denying that there's a contract, we're denying that there's a contract still in place. That stems from the second part, from the material breach, because she canceled the contract or terminated the contract. If it was a material breach, she had a right to terminate the contract. And alternatively, we claim that that Stovall acquiesced to the cancellation of the contract and therefore relieved Horton of any ability to any responsibility to comply with the contract, and put her back in the position where she could allege her half interest that was given to her in the quit claim date. Does that respond to your question? But we do very much contest that that there has been any acceptance of benefits here that has stopped Horton. If you steal $1,000 from me and you're gracious enough to give me half of it back, I don't have to turn it down in order to continue to claim that I'm entitled to all of it. All of what you took from me, I'm entitled to get back. That's essentially what the Supreme Court said in the Lopez case that we cite. And that's what happened here. Horton got back just a fraction of what she was entitled to by getting the $100,000. The settlement agreement called for 3 cash payments, 2 for $50,000 and 1 for $25,000. 2 of those were made apparently in a lump sum $100,000 payment, but Horton maintained she was entitled to much more. She maintained that she was entitled to $80,000 plus from deposits of her salary into a joint account, $300,000 from deposit of a bonus into her personal account, $56,000 in cash that she kept in a locked closet for one of her daughter's education fund. And let me digress on that last one just a bit. I mean, it sounds, frankly, it kind of sounds preposterous. Who keeps $56,000 in a closet? The first time I heard that. But nonetheless, Horton has summary judgment evidence on this. She has, her daughter corroborates it with very specific and detailed evidence in her affidavit that this is what they did, kept a large sum of cash in a locked closet, and that fortunately actually have Stovall and her employee on tape admitting that they saw the cash, that she had the cash, she found it, and she didn't return it. So it is not true. I'm sorry?
Just to clarify, those recordings aren't in the record, correct?
No, they're described in the record, but they are not in the record, to my knowledge. There, of course, were no objections that were, I believe, filed, but certainly not sustained, and no special exceptions either to Horton's summary judgment evidence. So there's no, and this would be an admission anyway, even if it wasn't caught on tape. It's just an evidentiary issue where we assert as as evidence that Stovall admitted that she found the $56,000 and did not return it. So it's just an additional evidentiary feature that we have that makes me much more secure in our position when and if we return to trial. This settlement agreement was apparently prepared in some haste. It obviously is in a handwritten settlement agreement. It was never typed up. It is extremely imprecise and ambiguous at points. It is in substance what I think you could determine as a property divorce settlement. That was in the pre-Obergefell time when Texas did not recognize gay marriage. And it was prompted.
Let me ask you something about what you're saying. It's vague and it is imprecise and it is ambiguous. And the two of you argue back and forth from some of the statements in Ms. Horton's affidavit about some of the personal property that it is not required by the contract. Nobody argued, or correct me if I'm wrong, nobody argued ambiguity in response to summary judgment or regarding summary judgment in order to get the trial court at that stage to interpret the agreement as to whether it did or did not require the return of the personal property that Ms. Horton claims in her affidavit or states factually in her affidavit was not returned. Am I correct?
I think you're basically correct. Certainly, Horton pleaded ambiguity, duress. The situation was that she was forced out of the house by threat of violence and left all of her stuff there. That kind of explains why the agreement is written the way it is. She didn't have a lot of bargaining power here. She was under duress when this was written up. So it appears to have been done in haste. Nobody specifically argued in the summary judgment pleadings that it's ambiguous, but clearly what Horton attempted to do, appears to me in her summary judgment pleadings, is to explain what she believed the contract intended. And I think that is permissible from the fact that she did plead ambiguity. I think she was entitled to explain what the contract meant. And of course, it was the movement's burden, if they were going to undertake it, to prove what the contract conclusively meant if they were going to obtain summary judgment. I would submit that they failed to do that. The contract, the settlement agreement, just like you would for a property settlement and a divorce, it divides the cars. It addresses the real estate, it addresses the bank accounts, it addresses Horton's personal property. And there's no indication that any of these covenants in the contract are anything but dependent covenants. They're all tied to one another because the intent is to effect a global resolution of all the property claims. It's essentially saying you get this property and I get this other property in return. That is the structure of the agreement. It does not contain a severability clause and is unreasonable to read the contract to resolve one property dispute in isolation, that is the centenary property, the claims to the centenary property, without respect to all the other covenants in the contract. There's no reason to think, in other words, that either one of the parties would have accepted the provisions with respect to the release of Horton's claim to the centenary property without all the other provisions. You determine the intent, of course, from the four corners of the contract. I agree with that, and there's nothing in the contract that conclusively establishes that these are independent covenants that should be considered separately from each other, which is the way that Stovall wants you to treat the contract. She essentially wants you to treat it as 7 independent contracts, and that she claims that she gave $100,000 in consideration for Horton to release her claim to the centenary property, and that's just not how it reads. It doesn't associate the two $50,000 payments as consideration for the centenary release. It is all interdependent. And I don't point to this as evidence on the first summary judgment. I just point to this as a confirmatory that our construction of the contract is a reasonable one, because in Horton and Stovall's second summary judgment affidavit, she says very much the same thing that I just said. This is how she describes the contract in her second summary judgment affidavit. On or about July 28, 2012, Hames and I entered into a written contractual agreement in which we divided property that we had bought together, agreed on ownership of other pieces of property, and I agreed to make various payments to disentangle our property interests and resolve all claims between us. That sounds to me very much like dependent covenants that are all intertwined. Stovall attempted to take advantage of these ambiguities, impreciseness of the contract in order to frustrate the intent of the parties. So she claims that, for example, well, I just couldn't find all this property that you claim that you left behind. I'm only required to give you back what I found, and I just couldn't find anything else. Well, that's a fact issue. Her credibility as to what she could actually find and what find is a fact issue. Stovall received from Horton 2 detailed, lengthy demand letters that describe the property that she asserted had been left behind at those 2 places that should have been returned to her if the contract was being performed in good faith rather than trying to frustrate the intent of the contract. And Stovall's denials that she couldn't find this property and that she had returned all the property that she could find is simply a fact issue raised by a interested, that implicates the credibility of an interested witness. And nonetheless, we did have, as I discussed earlier, actual evidence that $56,000 in cash was found and was not returned. That alone raises a fact issue, both as to Stovall's claim for summary judgment and Horton's counterclaim as to Horton's counterclaim on the second summary judgment. The same issue on the paychecks, the deposit paychecks.
As you're winding down your 3 minutes, I guess you're down to 2:45. Would you consider, if it's worth your time, to address the no evidence grounds and whether you do have evidence of damages? For example, is there evidence in the record of damages regarding the counterclaim about the Mercedes? And
Well,
I'll leave
Your Honor,
address whatever you think is wise to address.
yes. First of all, she never asserted a proper no evidence summary judgment motion or second summary judgment motion against us, because she never asserted that we didn't have evidence of damages. She said we didn't have evidence of damages on 3 of our 9 theories. And that's not what the rule provides. It doesn't provide for fractionalizing a summary judgment motion in such a fashion. But even if you consider it a proper no evidence summary judgment motion, all we had to do was provide some evidence of contract damages. We didn't have to marshal all of our evidence for all of our theories of contract damages. And we did present evidence of damages with respect to the failure to return paychecks, the failure to return the $300,000 bonus paycheck, and the failure to return the $56,000 cash that was found in the closet. So if she did assert a proper no evidence motion, we presented some evidence of damages that should get us to trial. That's my response to that. And I think we clearly raised fact issues as to other items that were not returned in the 2 demand letters, whether all the jewelry was returned, whether the car title was provided as the contract provided. Clearly, Stovall admits that she didn't provide the car title. She has excuses for that, but that just creates fact issues. Let me briefly address, since I have a whole 30 seconds, the attorney fee issue, because I think that's really a lot of what's driving the fact that this case is still alive, because there's about $60,000 in the registry of the court. And of course, one of the parties here has, Stovall, has passed away. Yet the case continues because we have money in the registry of the court. There couldn't be a more clear fact issue than the presentment issue here. Stovall claims she sent this email that she claims constitutes presentment. Horton says didn't get it, didn't get any demand at all. That's just clearly a fact issue. See, my time has expired.
Thank you very much. We appreciate it, Mr. Thomas. Mr. Clark, are you ready to go, sir?
I am, Your Honor.
All right. Well, we would tell you to approach the podium, but just make sure you're live. And Mr. Thomas, if you would take a moment to mute yours for a second. As you can see, we all cumbersomely reach for the screen, and our hands appear to be enormous when we are touching the mute or unmute. So thank you all so much. Ms. Clark, go ahead.
Yes, may it please the court. My name is Tom Clark, and I have the privilege and honor of representing Kim Stovall in this proceeding. This is, I believe, the last of 5 cases between Ms. Stovall and Ms. Hames Horton that spawned out of their relationship and how it ended. One of the issues that we've had with these cases over time was exactly what you see in this case, and that was a kind of changing of the facts, as it were, from case to case and from time to time. So clearly, when it comes to the issues that Mr. Thomas raised in his brief about how the pleadings went from an original petition through the 7th amended petition when our firm got involved, a lot of it was driven by emotion. And so there's a lot of clutter in that's not of good legal, should not have been put in there by the 2 lawyers who were running the case, which was essentially Ms. Stovall, who at the time was a trial lawyer, and Ms. Hames Horton, who was a disbarred attorney. Nevertheless, that's what we found ourselves with. And when we got involved in the case, we looked at it and said, this is an easy case. It's a breach of contract case. You guys had a settlement, and we're going to take out all of the clutter and all of these salacious allegations and go straight for the breach of the settlement agreement. There was clearly a settlement agreement on the Centenary property. It's specifically written out in the settlement agreement, and Ms. Hames Horton breached it when she filed the affidavit claiming the quitclaim deed, because she didn't have the original anymore. I mean, she literally had to go out and create a new document to breach the contract. In our motion for summary judgment, we were stuck with a situation that we inherited where the property had been sold because nobody could agree on payment of the mortgage. So once the property had been sold and the proceeds placed in the registry of the court, that's the $245,000. That was the net of the mortgage, which, by the way, was a contested motion. And that was the agreement they reached at the time of the hearing, was to put the money in the registry of the court to allow it to close. When we got involved, we said, okay, what are our damages from this claiming of title? Well, the damages are that Ms. Horton was claiming a 1/2 interest in the property. If we could have sued for specific performance, we would have. We couldn't sue for specific performance to get rid of the cloud on title because it had already been sold. All we had left to do was to claim all of the proceeds. So our motion for summary judgment, contrary to what Mr. Thomas said, in paragraph 4.22 of our motion for summary judgment, the clerk's record 452, was that Stovall, as the damages for breach of contract, is entitled to release of the proceeds from the sale held in the registry of the court. Now, because this case had another problem on top of it, we were in Judge Lister Brown's court. And Judge Lister Brown at the time was having her own health issues. And so we ended up in front of Judge Moyer. Judge Moyer was not willing at that time to step on the toes of Judge Lister Brown by ordering money to be dispersed from the registry of the court. And so he ended up fashioning the judgment as the amount that was in the registry of the court.
Well, I'm going to add something here because Judge Moyer did a wonderful job. We've had a number of cases where he stepped in as Judge Lister Brown was getting treatment and dying to help out her court and keep it moving. But that doesn't, every judge has to make the right decision. I'm just wanting the record to accurately reflect that he was stepping in to help her out. Go ahead.
Absolutely. And Judge O'Neill also stepped in and handled some of the orders and some of the hearings, and all the judges did a great job. And everyone was hoping, obviously, well for Judge Lister Brown, and it didn't turn out. But we have the damages in our motion, and that's what Judge Moyer actually inserted in there. And then we had to file a separate motion, which I believe was heard by Judge Lister Brown, to release the proceeds from the registry of the court so that Ms. Stovall could be made whole. And as we cited in our brief, the damages for breach of contract are to place the injured party in the economic position it would have occupied had the contract been performed. If the contract had been performed, Ms. Stovall would have received all the money. The result of what the court ordered in the two different orders was that Ms. Stovall received all the money from the sale. So it put her in the economic position she would have occupied had Ms. Hames not breached the contract and had she performed under the contract. So we feel like the damage award was absolutely appropriate. I noticed in Mr. Thomas's reply that he claimed that there was somehow a double recovery, and I have to admit I didn't follow that, because we were only allowed the one recovery of the proceeds of the registry of the court, and it's been satisfied. That's done. As it relates to the response to that motion for summary judgment, we've addressed the issues that were actually in the settlement agreement, and then a lot of what Mr. Thomas just talked about were issues that are not in the settlement agreement. The $56,000 that was in the closet is not in the settlement agreement. The $300,000 bonus, there's nothing about a bonus in the settlement agreement. All these other issues are not in the settlement agreement. Those, as Mr. Thomas conceded, were the tort claims that we filed a motion for summary judgment on, and one on statute of limitations issues. So I'm going to ignore all the ones that are not in the settlement agreement, as we're only focusing on the breach of contract. The personal property, again, the personal property that was identified in the settlement agreement was all returned. The personal property, the stuff that was put in the storage unit, y'all have read the settlement agreement. It's very specific. Stovall at that point in time had put property in a storage unit, and the agreement was, here's the key. That's it. There was no breach that Ms. Stovall had in relation to providing the key and giving Ms. Hames Horton access to it. With regard to the paychecks and the two accounts, there were clearly two accounts. Actually, there were more than two accounts, but for these purposes, there were two accounts. One was a joint account, which is referenced in the settlement agreement. And that, as Ms. Stovall stated clearly in her affidavit, is where Ms. Horton's paychecks were deposited to pay for her half of the living expenses. Ms. Hames Horton had another account that was a personal account. And in that account is where she allegedly had some money. And you've seen the allegations that she actually diverted that money from the law firm. But in the affidavits that Ms. Horton filed in response to the first motion for summary judgment and in response to the second motion for summary judgment, she actually describes those variously as two different things. She says that paychecks was one thing, and that she was owed back paychecks, and then that she was owed a bonus. She literally describes those as two separate things by the time she gets to her second affidavit in response to the second motion for summary judgment. But the settlement agreement is clear. We're only looking at paychecks. So Ms. Stovall looked in the account where the paychecks went, determined that there were none. That complied with the settlement agreement. As to the title for the Mercedes and the $25,000 payment, we'll start with the $25,000 payment. Time was not of the essence, and the only complaint there is not that she didn't receive it. The complaint is that she didn't receive it by July 25th. But Ms. Horton did receive the money through her husband, Mr. Horton. And there's no question about that. And time is never a material breach, or not very often a material breach, as we've cited in the brief, the cases on that. The same is true with the title to the 2009 450 Mercedes. There's no time element as to when that has to occur. And then to your point, Justice Evans, when you look at when we filed the no evidence motion for summary judgment, the second one, we asked for what damages did you suffer? Were you prevented from selling it? Were you prevented from recovering the benefit of it? And there's absolutely nothing about damages arising from that failure. On the breach of contract, we did raise the benefits of Stovall, and Justice Evans, I know that you have, you probably saw this. The settlement agreement clearly says that the $100,000 is for two things, and one is for living expenses. It's prospectively, and the other one is to pay contractors. That's not other money that's owed, as Mr. Thomas argued. That was money that was given for a specific purpose, and she kept it. Ms. Horton kept it. So she accepted the benefits of it, and then in her live pleading at the time of the summary judgment motions, she was seeking to enforce and get the benefits of that same contract. And we feel like both of those arguments show benefits to Stovall, which would result in affirming the summary judgment on the breach of contract.
But it sounds as though you're using benefits of Stovall to say that Stovall can never have breached first.
No, I'm sorry.
Because I read and hear Mr. Thomas's argument, read the brief to say Stovall's problem in this case, says the Horton side, is Stovall breached first. And that therefore, Horton was no longer under the obligations of the contract and could go ahead and file the quit claim deed that Horton claims had been signed and you all may say is fabricated. But I don't see how benefits of estoppel plays into that if this is a first breach case. So help me with it, because Horton is not saying a contract never existed or I was never bound by the contract. She was saying I'm no longer bound by the contract after Stovall breach, materially first breach.
Right, and that would be the key, is the materiality of the breach. And the only two breaches that she really alleges that didn't happen were the payment of the $25,000. And again, that's a timing issue and how it went. And the other one was the title to the Mercedes. And there's no, since there's no evidence of damage on either one of those, I don't see how they could either one be material. So if it's just a minor breach and not a material breach, you're about to hit.
Well, when you say there's no evidence of damages, to me, that's a big red flag. Whoa, we put the brakes on. Whether or not you prevail on the counterclaims in trying to get rid of those counterclaims, Horton has no obligation to show that the first breach caused damages. She just has to show that there's a first breach. And so when you go towards saying, well, title of Mercedes, and there's no showing that there's damages from that, well, it's title to a Mercedes that she had contracted to get. And that I don't see anywhere in this file where your client says, yes, she did sign over the title to Ms. Horton, and it was on her to go get it straightened out with the Texas Department of, I don't know what, public safety or wherever we get our titles straightened out. Same with the $25,000. It doesn't seem like it's not like you all show a check that was transmitted somewhere close to that deadline. You're trying to say, well, there's other payments and those were really the $25,000 and whatever. And Horton's saying she didn't pay the $25,000 on or before the date in the contract. And she's trying to say that's material. $25,000 when you got individuals involved kind of sounds material.
In this particular instance, the difference there is on the materiality is that the money was actually received, and Ms. Stovall says it was delivered in the roundabout way, and it was used for the purpose that it was supposed to be used for, that was in the settlement agreement.
So why is that not a factual dispute? Horton says no, Stovall says yes, roundabout. And why are we resolving that dispute on summary judgment?
Because there was no question that Ms. Horton got the money. And so it's just a question of trying to create a fact issue that didn't exist. Everybody admitted that she got the money, and it's just a matter of how it got there. That the money.
Doesn't the fact show that she got that money before the settlement agreement was executed, though? That's the case. Why would she agree to pay that money she'd already paid?
Her husband had gotten the money, and at that time he wasn't her husband. At that time he was James Horton, the plaintiff in the underlying personal injury case where all the money came from. So Mr. Horton had the money, and Miss Stovall asked Mr. Horton to convey the money over to, at the time, Miss Hames, who much later became Miss Horton. And so the money actually went that way. That's the trail it went. It wasn't like it went from one Horton to the other. It wasn't all sent to one joint account for the Hortons, and we said, okay, use that money instead of this money. It was literally two different people that were not related by marriage at the time.
One other clarifying question I have. Ms. Stovall did repossess the Mercedes, did she not?
I believe she did.
Help me with where is that in the record? And when did she do that? For example, I'm very sensitive to the dates because there's a lot of complaint about the $345,000 transaction. That was long after the settlement agreement. That's on July 23. So there's no way that transaction is a part of the settlement agreement. So let's talk about the Mercedes. When was it repossessed? And is there evidence in the record of that?
There's no evidence in the record that I'm aware of, Your Honor. And I believe it was repossessed, but I didn't follow up on that. I don't know the answer.
I think Ms. Horton testified that it was repossessed on December 8th of 2012.
Was that in her deposition?
I think that's at Clerk's Record 1125. She hired a person to break into her house and stole her car.
Oh, okay. Yeah, that's part of those allegations that I don't know what car. Does it say it's the Mercedes that was stolen?
It says her vehicle.
Okay, because there were three vehicles that were involved in the settlement agreement, and I had trouble following which one was which. And I don't know what was taken. I don't know what to believe in that regard, other than I'm not sure that it had any bearing on the summary judgment motion because we were just dealing with breach of contract at the time. And that, of course, is a tort to go break in and steal something. And that was barred by limitations when it was finally asserted. I don't know how to answer your question any more than that. As it relates to the, I'm going to move ahead since I only have about 4 minutes left, unless you want to stay on this issue. No, okay. As it relates to the attorney's fees issue, the affidavit that I put in the summary judgment record shows segregation. We had over 400 hours in the case. A lot of it dealt, of course, with torts. Nobody ever complained about the hourly rate or the segregation that was provided at the time. I think that provides evidence of segregation. On the issue of presentment under breach of contract, we submitted the email from Ms. Stovall. Justice Evans, I think you recently had a case, Sandberg versus ST Microelectronics, where you dealt with a similar issue involving an email of a demand to an employee to return proprietary information. And you found that the email demanding return was sufficient to constitute presentment. We have a very similar issue in this case where we have an email saying, get rid of the lien, and she refused to get rid of the lien. So it told her exactly what she needed to do to avoid it. And again, this is another one of those where Ms. Stovall says she sent it to an email address. She was instructed by Ms. Horton to use email, and she sent it to an address that was live. And I would point out that even as late as the first summary judgment motion, the second line of Ms. Horton's affidavit said, after she says, my name is Robbie Lisa Horton, she says, my email address is, and she uses the exact same email address. So the fact that it was sent, I think, is actually very proven in the record. The fact that she vaguely says, I didn't receive one, it was also sent to her agent, to her husband, who was her husband at that time. And there's no allegation that she didn't see it, read it, and that her husband got it. So we think we've properly proven presentment. And in addition, we also have the allegation that the declaratory judgment action, which is part and parcel of the breach of contract action, that the court could have awarded under declaratory judgment action. We did not see that this was a trespass to try title because there was no title left to try at that time. It was simply a matter of who was entitled to the money in the registry of the court. And so therefore, we felt like when Ms. Hames asserted a declaratory judgment action and we prevailed on that, that would support the same award of attorney's fees. And then on the severance of the counterclaims, there are specific elements. We list them at the very end of our motion, of our brief, that list the elements of a compulsory counterclaim.
Help us with the severance argument, because if we were to reverse, what do we do with that when, we've issued opinions in this court that have dealt with several of these other cases. And one of them is the case involving the bank and that account. And the opinion clearly recites that after the bank received summary judgment, it non-suited its claims against Ms. Stovall. The case goes up on appeal, and the opinion even took time to say Ms. Stovall is listed as a party, but she's not a party to this appeal because she was dismissed. So there is a severed case that's been abated down in the trial court, and those claims have never been resolved anywhere on planet Earth. What should we do about that if we were to reverse this case?
Reversal on the severance is a good question, because they were severed out of this case, but they were never refiled in another case. I would almost say that's waiver at that point, but that is a very good question. I really don't have a good answer for you. I'm sorry. I hate to end on that note, but I'm out of time. But affirm the judgment. Okay.
Thank you very much. Thank you so much. And if you all would switch who's mute, who's live. Mr. Thomas, you need to get that on. Thank you both. Mr. Thomas, you ready, sir?
Yes, sir.
All right, go ahead and proceed.
No, don't affirm the judgment. Reverse the judgment. Let me address a few things that Mr. Clark has said. He says the $56,000 found in the closet was not part of the contract claim. The bonus was not part of the contract claim. Returning personal property is not part of the contract claim, but of course it is. It's all part of the contract claim. It's just part of Stovall's attempt to avoid her obligations of the contract by attempting to narrowly interpret it in a manner that makes no sense. With respect to the $56,000, even using Stovall's strict interpretation that she could determine what to give back by only what she claimed she found, we have disputed, controverted evidence that she did in fact find the $56,000 and then failed to return it. So that is definitely covered by the contract. With respect to the bonus paycheck that Ms. Horton received, Stovall wants to say, well, a bonus isn't a paycheck. Well, most people, I think, would consider a bonus that you receive for the work that you have done over accumulated years to be a paycheck. Certainly, a jury could conclude that a bonus paid to Ms. Horton is encompassed within the term paycheck. And the contract provided that Ms. Stovall would look through the accounts and return deposits of paychecks. Now, she wants to interpret that to be a meaningless act. She said, oh, I looked at these and I can't find anything and I'm not going to return anything. But she admitted that she saw the $300,000 deposit in Horton's personal account, which somehow Stovall's name gets on, and she's allowed, which she then closes and takes all the money out of the account, but she doesn't return that. And a jury can very well decide, probably will decide, that that was $300,000 paycheck that Stovall took and did not return, and that was a material breach of the contract. So only the tort claims were severed out. The contract claims were not. And that's part of the reason, because they're so interrelated, that's part of why the trial court abused its discretion in severing out tort claims with respect to the money in the Chase account, because it was all related to the contract claim and it had never been brought in any other suit. It had only been brought in this first filed suit, and that's where it should have stayed and where it should have been tried and where it should be tried if the case is remanded. The court should be instructed to reconsider its severance of those tort claims.
Well, what we're evaluating is the correctness of the judge's decision at the time of the severance, or are we rolling the camera forward and judging that decision, but based on the developments, namely that the bank got summary judgment, dismissed Stovall, the case is over, it's been affirmed, it's all done and gone. And do we use that state of events, or do we use the events at the time the judge decided it? Do you know? I mean, I'll tell you this, I have full confidence. I think this is now Judge Moore, right?
Right.
I have full confidence. She didn't have the time to try the case twice. But the question is, do we reverse, or do we leave it to her good sense to go ahead and combine this thing for judicial efficiency and try all your claims between all of you together at the same time?
However we get there, that's where we should get. But you know, it's sort of both, to be honest. You look at whether the court erred at the time, surely, but subsequent events very much confirm for us that that was error, that was an abuse of discretion, because it was I'm not using future events to try to prove the error. I'm using future events to say exactly what we said at the time. That was a perfectly predictable result of what was going to happen. It never should have been severed out, because it wasn't a proper thing to do at the time, because it wasn't going to get tried that way, because those were different claims asserted in the other case that had been asserted. That other case involved what Chase's duties were, not what Horton and or Stovall's duties were vis-a-vis Horton. So in a sense, what I'm saying is that future events confirm that it was an abuse of discretion, and the tort claim should have never been severed out.
That's a great argument. Thank you all so much. Your time is up at this point, and we really appreciate it. We all would have preferred to have done this in person in the courtroom and have you all present. Do either of you feel like some way that this operated, you were deprived of making your arguments that you needed to make, beyond that you might have wanted 40 minutes instead of 20, which we almost never give?
No, Your Honor, I think this worked quite well. I don't have any complaint with the procedure.
Mr. Clark?
I had no complaint either. It was, whereas I'd like to see your expressions, I can actually see them quite well on the screen. So I think it was just fine.
That said, Your Honor, I very much believe in the in-person oral argument. I hope that this is not an ongoing substitute for in-person oral arguments when we can hold them.
I don't think anybody's thinking of it going on any longer than we have to do, but we may have to do it a while based on, you know, there's no vaccine, there's no immunization. We don't know. We're going to be making decisions that are above my pay grade as to how we're going to conduct oral arguments as we get to the fall. Thank you all very much. This will conclude the oral argument in the case of Horton versus Stovall, 0516 00744CV. We appreciate your time. And with this, we'll ask Lisa to go ahead and to terminate the Zoom oral argument. Thank you all very much.